Hello, I'm Christopher Badger.
And I'm Mark Davies.
We're barristers at Six Pump Court and would like to welcome you to the latest Environment Law News podcast, brought to you in association with LexisNexis. In this podcast, we look at the European Court of Justice's latest foray into attempting to define waste, the latest fine handed down to Thames Water, and another novel use of corporate law for environmental aims. First, we look at the case of Openbaar Ministrie against Tronex BV.
Yes, in July, the European Court of Justice handed down its decision in this case, and the judgment is likely to be of some interest to those dealing with questions about the meaning of waste, particularly those dealing with consumer electrical products which have been returned by consumers.
So a fairly limited audience then.
Well, yes and no. As Attorney General Cockott put it at the start of her opinion, this case once again deals with the questions about the definition of waste under the Waste Directive. So it is a little broader than simply electrical products, although that's what the case was about.
So what can we learn from the case? And does it finally create the longed-for logical coherence in the ECJ case law about waste that Lord Carnworth has been seeking?
Good questions, and the answers are not a great deal and no. By way of background, Tronex is a wholesale stockist which bought some goods for the mighty sum of €2,396 and wished to ship them to a third party in Tanzania.
So not a whole lot of money at stake.
Not at all, but an important industry principle. The goods consisted of, and this is from the judgment, goods from retailers, wholesales and or importers. The consignment of goods consist of electrical kettles, steam irons, fans and shavers. Most of the appliances were in their original packaging, although some of the appliances in the consignment were unpackaged. The consignment consisted of appliances which had been returned by consumers under a product guarantee on the one hand, and goods which, because of a change to the product range for example, were or could no longer be sold, normally, on the other. A number of boxes in which appliances were packaged carried a notice stating their defects. For example, the glass in some of the glass kettles was damaged. Now, the shipment was to take place without notification or consent in accordance with the waste shipment regulation.
And at first, the Dutch court held that the products were waste and fined the company €5,000 for not obtaining the authorities' consent before shipping under the EU Transfrontier Shipments of Waste regulation.
Correct. And the kernel of the court's decision, and again quoting here, was that the shipment to a third country of a consignment of electrical and electronic appliances, such as those at issue in the main proceedings, which had been initially intended for retail sale, but which were returned by the consumer, or which, for various reasons, were sent back by the retailer to its supplier, is to be regarded as a shipment of waste within the meaning of Article 1 of Regulation 1013/2006, read in conjunction with Article 2 and Article 3 of Directive 2008/98, where that consignment contains appliances, the good working condition of which has not previously been ascertained, or which are not adequately protected from transport damage. Such goods which have become redundant in the seller's product range, and which are in their unopened original packaging, on the other hand, must not, without indications to the contrary, be regarded as waste.
Well, that doesn't really seem to help with the definition of waste.
Not at all.
And what of the question of the judgment creating a logical coherence to EU waste law?
Again, sadly, the judgment isn't really of any help. What the ruling appears to require regulators to look at is a consignment and come to a conclusion about the different types of products contained therein, finding that appliances that have not been ascertained to be in good working order, or which are not in their original packaging, are waste, while those products in their packaging and in good working order are not waste.
Well, that's obviously going to be difficult in practice for regulators, particularly when they're faced with a container in a port which is filled with a mixed consignment of products. I mean, you only have to take the recent case of Biffa Waste Services Limited. Although it involved different facts, it's an example of just how difficult it is to take a container of material and categorise it either as waste or, as the defendant asserted in that case, mixed paper.
Yes, the judgment in Tronex doesn't seem to give any certainty to industry or aid regulators in enforcement. On to our second story, the latest fine for Thames Water.
Absolutely. Now, it's important to have some historical context here. Remember, only just back in 2015, Thames Water attempted to appeal a fine of £250,000 imposed by the Crown Court at Reading for water pollution offences. Now, in December 2018, Thames Water were fined £2 million by the Crown Court at Oxford, following its guilty pleas to 3 charges of making discharges of untreated sewage into a brook in the Cotswolds, as a result of which 146 fish died.
Heady stuff.
Indeed. And at the start of August, the Court of Appeal upheld that penalty, despite inadequacies in the reasoning process of the trial judge, a fact which, it was said of itself, did not take Thames Water very far. The offences were the result of what the judge had found, after a Newton hearing, to be a reckless failure to put in place and to enforce proper systems for the maintenance and monitoring of pumps.
Isn't it always pumps?
It certainly seems to be. The Court of Appeal reviewed the sentence by reference to the guideline, the most interesting aspect being the proper treatment of Thames Water as a very large organisation, with a turnover exceeding 40-fold the £50 million per annum, by reference to which the guideline sets its tariffs for large organisations.
And of course, Thames Water set the record in 2017 for a fine for this kind of offence, with £20 million imposed by the Crown Court at Aylesbury.
It did, and the judge at Oxford accepted that the offences before him in this case were more Reading than Aylesbury, but he nevertheless imposed a fine 8 times larger than that imposed at Reading. However, the Court of Appeal pointed out that in 2015 it had remarked of the Reading fine that it would have had no hesitation in upholding a very substantially higher fine on that occasion. The court declined the invitation to create its own guidelines as to the sentencing of very large organisations, beyond those to be found in the 2015 appeal. And the court is not bound by, or even bound to start with, the range of fines suggested by the Sentencing Council in the cases of organisations which are merely large. The court stressed the need to achieve the guideline objectives of punishment, deterrence, and the removal of gain.
It's hard to see how that isn't the object of any sentencing process.
Now, for our last story, we look to the latest win for ClientEarth and how it did it.
Yes, now, corporate law and environmental law might not, at first blush, seem like the likeliest of bedfellows, but there is a growing use of corporate law mechanisms for the advancement of environmental aims and the protection of shareholders' interests.
In the most recent case, ClientEarth secured success in taking shareholder action against ENEA, co-owner of the project behind the €1.2 billion construction of the coal-fired power plant Ostrołęka C in Poland. The action was advanced on 2 grounds. The first, that the company resolution authorising the construction of the power plant was an impermissible instruction to the management board of the company, and therefore legally invalid. The second, that it would harm the economic interests of the company, and should therefore be annulled.
Yeah, quite right, and the district court in Poznan agreed with ClientEarth on the first ground, which really demonstrates the impact that corporate law challenges can have in furthering environmental aims. And it's something that I think all corporations acting in areas liable to environmental challenges should be aware of.
Absolutely. But as the court found in favour of ClientEarth's arguments on the first ground, it did not sadly determine whether the construction of the plant would harm the economic interests of the company. I don't think that that should detract from the attractiveness of the argument, though. Where a company is proposing to create an asset for which there is compelling evidence to assert it will become stranded, directors should be increasingly aware of the risks arising from shareholder action. The growing trend towards a greening of finance must only lead support to this warning.
Absolutely, and with President Macron threatening to block the EU's trade deal with Brazil unless it takes action in respect of the forest fires in the Amazon, it seems like environmental issues are starting to play a more and more prominent role in trade and finance issues.
As we've said before, an area to watch. Thank you for tuning in for this Environment Law News podcast. For more information on any of these stories, or if you would like to discuss any of the topics raised in more detail, please contact Six Pump Court on 0207 797 8400, asking for either Christopher Badger or Mark Davies, or contact our colleagues at LexisNexis in the PSL Environment team.